Meal rest breaks, key point on this before I move off the point, you have to record those 30-minute meal breaks. You should be recording the begin and the end of the 30-minute meal breaks. You do not have to record the 10-minute rest breaks. Now, everybody knows about the Brinker decision. We've had that now, I think, since 2013, I think, if I recall correctly. Huge benefit for California employers. Again, you're not required to force everybody to take the 30-minute meal break. You need to make them available. If employees work through the 30-minute meal break, that doesn't automatically create liability for the employer. But now, what's the problem with that? If you've got records showing that nobody's taking a 30-minute meal break, and your default argument was, well, it's available, but everybody just wanted to work through it, it's going to be really hard to defend that claim. So a lot of employers are just going to this mandatory, require everybody to clock out for the 30-minute meal break. And it has to be a full 30 minutes before the end of the 5th hour. So a lot of employers are doing that and monitoring the time records to make sure that the employees are clocking out. And if they're not clocking out, either following up with the employee and asking why they weren't able to clock out. And if they were, say, I was just too busy, it was a busy time. A lot of employers are going to the practice of going ahead and paying out the extra hour of premium pay for the missed meal break. And I like seeing that. If I'm defending a case, I like having an employer that has paid a few of those out every now and then. Because one, it shows that you've got an effective policy that if somebody misses their break, it can be resolved, or if somebody complains about missing a break, you've got this complaint procedure that they can utilize to get paid what they're owed. And then you've got a good defense saying, well, they never complained, and if this employee had ever complained like these other employees, they would have been paid. Why didn't this employee complain? And you've got a good defense on that argument. The case, Rodriguez versus Taco Bell, presented the issue to the court where the employer, Taco Bell, provided employees with a discounted meal if the employees ate the meal on the company premises. The employees sued Taco Bell, alleging that this violated the provision of an employer providing a duty-free meal break to the employees. The court in this case held that Taco Bell had actually provided the duty-free meal break under California law and under the regulations as the California Supreme Court set out in the Brinker case. And because the obligation to eat the meal on the company premise was only voluntary, the employees did not have to choose to get the discounted meal and could have left the company premise if they wanted to, but they just wouldn't have been able to get the discounted meal break. The court held that the employer did in fact offer a duty-free meal period for these employees. So it's a good reminder to California employers that they have to provide duty-free meal breaks and rest breaks to employees in order for the meal break to be effective. A recent case that held against the employer was the Augustus versus ABM Securities case, where the employer had a pager that the employee had to monitor during their meal or rest break. And in that case, the court found that the employees did not have an effective 10-minute rest break because they had to monitor the pager during the 10-minute rest break.
Paying the penalty pay is essential to making sure that your record as the employer shows that in good faith you've done everything possible to pay out your employee when it was due to them. However, I used to have a guardrail in place so they couldn't miss more than 2 meal periods before their 5th hour in a 2-week period of time, and if they did, they would be documented for it. So adding a layer of discipline brings their attention to it because they don't want to be written up, because they don't want to lose their job. But it goes back to that consistent communication that we were talking about earlier.
Great question. It's called the early lunching, and Brinker, in the case that went up to the California Supreme Court, did exactly that, would have people clock in and work for a period of time. And the California Supreme Court said, yes, that's okay, but then didn't define when it's okay and when it's not okay. They said when it's reasonable. So what I'd like to see on the early lunching like that is have employees clock in and work at least 45 minutes or an hour. I don't like this where they clock in and immediately clock out for a 30-minute meal break and then clock in for the next 8 hours. Have them do some tasks up front and for like an hour or so. I think that's a very defensible claim, and then clock out for the 30-minute meal break, clock in, and then you're good for the full 8-hour shift at that point. So meal break waivers in the restaurant industry, and don't confuse these with on-duty meal break waivers. There's two different types of waivers. There's a waiver that I do recommend you implement in the restaurant setting, and that's a waiver. The employee can waive their meal break if their shift is less than 6 hours. They can waive it. And I do recommend having that as a blanket waiver. You can put that in place when employees are signed in the new hire packet, saying if you work less than 6 hours, are you going to waive your 30-minute meal break? And if they say yes, that's enforceable. That's good to have in place. Now, what I don't like, though, are these on-duty meal break agreements, or they call meal period waivers. A lot of employers call it, where it's like one employee behind the counter. What if, could you just waive the meal break? In the restaurant setting, you can't. There's been an opinion letter by the labor commissioner, basically in a fast food establishment, asked if the employee or the manager was the only one that had certain duties, access to the safe, could resolve certain customer complaints and things like that, and said, look, they take their meal break, it's back in the office, but they're on call. If something comes up, they need to be there to deal with these issues. And the labor commissioner said, no, that's not enough. There's no reason that the assistant manager or somebody else couldn't fill in for that 30 minutes, get them to take a full 30-minute meal break and then come back.